Hi, everyone. I hope you're having a good weekend. Um, I wanted to come on today and talk about the ABA standards for criminal justice, DNA evidence, and a little bit about IgG, the haplogroups. I also learned a little bit of something about predictive STRs in relation to IgG and identification in general. So, if you see here, I brought up another article. Thank you, Sarah D. Irish. She found this for us. And she found this. Just give me just a moment. Oh. Now I have this song stuck in my head. Hold on. Let me get it. Oh, it doesn't want to find it now. Okay. Okay. So, this is the ADA standards for criminal justice, DNA evidence. Starts on page 16. All right, this is it. Part 2, collecting, preserving, and use of DNA evidence. Standard 16 through 2.1. Collecting DNA evidence from a crime scene or other location. Whenever a serious crime appears to have been committed, there is no reason to believe that DNA evidence relevant to the crime may be present at the crime scene or other location. That evidence should be corrected promptly. Whenever DNA evidence is to be collected by law enforcement, a law enforcement officer or other official forensic investigator properly trained in the identification, collection, and preservation of DNA evidence should be dispatched to the location following written guidelines, should identify, collect, and preserve that DNA evidence, taking reasonable care to ensure that collection is representative of all relevant DNA evidence presented. So, That makes me think we don't really know who collected the DNA evidence. Didn't Brett Payne say in the PCA he could see the sheath from the door? But my question is, when the bodies were removed, and I'm not sure if the coroner was actually a part of that process or not, why wasn't the sheath seen when the bodies were being removed? Because if it was visible, if Brett Payne claims it was visible on his, well, he said later noticed a sheath, so he couldn't have seen it from the door. So does that mean it's actually on a body cam? I'm not really sure. Hello, Christy Nevada, commercial zone. He could see the sheath from the door later. Okay. Thank you. Great. Thank you, commercial zone. Chloe Penny, welcome. Welcome, commercial zone. Christina Nevada and Chloe Penny. Right? This is my exact question, because this is the question, commercial zone, that popped in my head by just reading B under these rules for collecting, or these standards, sorry, not rules, standards for collecting DNA evidence. That's exactly it. Hello, everyone. It's very good to see you. Let's see. So, if a defendant has been charged with the crime under investigation and the defendant's attorney or investigator is denied access to a crime scene or other location after completing law enforcement's investigation at the scene or location, the defendant should be permitted to seek a court order to allow the defendant's attorney or investigator reasonable access to the location and permit a representative of the defendant's attorney properly trained in identification, collection, and preservation of DNA evidence to collect DNA evidence. Misty, welcome. Oh, it's so good to see you. This is Commercial Zone says, Kathy Commercial Zone, this is such an important topic, Audrey. I'm expecting a motion to dismiss based on the IgG DNA Fourth Amendment. Interesting. Could you elaborate a little bit more into your thoughts there? I mean, it is such an interesting, it's important and interesting topic. So, Standard 2.2, Judicial Order for Collecting DNA Samples from a Person. A DNA sample should not be collected from the body of a person without that person's consent unless an authorized search warrant or by a judicial order as provided in subdivision B of this standard, except in extringent circumstances. A judicial order for collecting a DNA sample from the body of a person should be issued only upon notice and after an opportunity for hearing, at which we have very big deadlines coming up. But I personally don't have much faith in these DNA. I mean, this DNA. Well, I don't have faith in DNA either, but these deadlines, because the state has been able to get away with basically most of everything that they've tried. And I don't think all of the evidence, all of the discovery that the defense is requesting, I don't think the state is going to discover it all or hand it over. Payne said he saw it. In Baker's PCA, he says ISP people informed him about the sheath. Right, Lenny, you bring up a great point because not only does everybody have a different description of where it was found and how it was found, nobody can really agree on where it was found. But yes, it was on Maddie's bed, but was it to the right of her? Was it tucked under the comforter? Was it actually under her or next to her? I think the location of it, that's going to matter in the chain of custody, right? Because the chain of custody should match what these official documents are saying, right? State discovery cut off this week and objections to the death penalty. I think the Fourth Amendment unauthorized search on how they got to BK regarding the IgG DNA. I reread J.J. Long 10/25/23 order on the motion to compel last year. Hey, and if anyone's in here and they don't and you haven't met Commercial Zone yet, she has a fantastic podcast. She goes over the motions on the docket. They're very quick, short format. I think 5-minute episodes. They're so easy and formative to listen to. And so what she's saying here is that yes, we do have the cutoff and the objection coming up. And she thinks the unauthorized search on how they got to BK. I'm sure more of this information is in her podcast. She's on, I think, Apple and Amazon, Podbean, and you're on YouTube. Let me see if I have your things here. So that's very interesting that you say that. Um, I can't find anything. I'm so sorry. It better be seen on the body cams from the crime scene. And that's interesting you say that too, Clopenny, because I'm curious whether they're just going to show a picture of it laying on a table at the precinct. To me, that's not going to be good enough. It's got to be on the body cam the crime scenes. Clopenny is listening to Kathy's podcast. There's a search engine if somebody wants to search for like change of venue, IgG, DNA on Listen Notes, Apple, Amazon, Heart, Kathy's Indie Zone v. Kohlberger. Yes, Misty, I watched that. I did think he was very fair to both sides. Yes. Oh, here we are. Where are you? Okay, here we are. I found Commercial Zone's YouTube. This is her new channel that, what'd you say? It was an entrance to all of your other podcasts and the different platforms your podcast is on. And can you get through that through your YouTube channel, Commercial Zone? Okay. So, if the person whom the sample is to be collected is suspected of committing a crime, an order should be issued only upon application of demonstrating probable cause that a serious crime has been committed, and if the sample is to be collected from a person, is a sample collected by a physically non-invasive means, reasonable suspicion that the person committed the crime charged. I'm stopped here at this one, number B1 under this subsection, because if in fact Brett Payne did not have any of the source material needed to make the claims about the route he claims a car went in the second AT&T warrant, then how do they have reasonable suspicion? Because Cyril rightly pointed out, there's a lack of evidence there, and because of what he's seen, he says it's exculpatory. So I don't know if what the information he's seen tends to indicate Brian was somewhere else, or is there just a lack of information from the state supporting their claims? So right here, they shouldn't have been able to take that DNA sample just by this alone. And from what I can see so far, there are misstatements about the cell phone data. And so Cyril was also saying you collect it all. You collect the video, you do the drive testing, you get the lock bar, you get all of these things. You put everything in a mapping program, you get the mapping, then you use the mapping, among other things, before CAS makes their draft. And Payne did not have that information. So he shouldn't have been able to get the warrant. And two, that means Brett Payne had said there's no video of the car. Cyril said there isn't video of the car to support the routes that were alleged in these affidavits. And Aunt Taylor has also been saying, I don't have these videos. Where are they? Where are the videos of the car that you allege? So right here, they should not have been able to take that DNA evidence. So Misty says, I've always thought the sheath was the biggest red flag in this case. They cannot get to BK without the burglary charge. Yet, cops always said no signs of break-in. That is a very interesting point too, Misty, yes. Commercial Zone says, great points, Audrey. A lot of questions, but what's hurting the public is the warrants are under seal, right? Still nearly 2 years since the crimes. That's amazing. You would think to, not only boast the morale of Latah County of Moscow, to show the world what Moscow is and what Moscow does, they should be in a unified front saying, we have the evidence to show this person did this. We are going to prosecute this person to the full extent of the law to the best of our ability. We don't care where you want this done because the evidence we have is going to convict anyway. I don't hear them saying that. And all I hear is excuse after excuse. All I hear is they're fighting tooth and nail to keep this in a biased county. To me, in my opinion only, that means they need that. They need the bias to help with their case. And that should never be. That should never be. I say unseal everything. Me too. I have asked the question, like, to Anne to request to have everything unsealed, and of course the state is going to object, but that'll force them to say why. And it shouldn't be, oh, well, it will compromise the investigation, or, a law enforcement will make the public feel unsafe, or whatever those, 4 points that are copy and pasted in each one of those sealing documents. All right, I'm on number B2. A sample collected by physically invasive means, probable cause that a person committed the crime charged, and that the sample will assist in determining whether the person committed the crime. And that's the problem with trace DNA. Trace DNA could have matches, semi-matches, partial matches, but that doesn't mean they actually committed the crime because we don't know when trace DNA arrived at a crime scene. That sample will assist in determining whether the person committed the crime. If the person from whom the sample is to be collected is not suspect of committing a crime, an order should issue only upon an application demonstrating probable cause that a serious crime has been committed, and that the sample is necessary to establish or eliminate that person as a contributor to or source of the DNA evidence, or otherwise establishes the profile of a person who may have committed the crime, either because there is reason to believe that that person has contributed to or been the source of the DNA evidence, or for other good cause shown that the sample of that particular person is necessary for that purpose. Number standard 2.3, judicial order for DNA samples collected by non-law enforcement entities. When a hospital, clinic, laboratory, or other non-law enforcement entity has collected a DNA sample from a person for a purpose other than criminal investigation, law enforcement should not obtain or otherwise have access to that sample without the consent of the person who is the source of the sample, unless authorized by a judicial order under the conditions provided in Standard 16.2.2 by search warrant. Okay, so I'm not sure that particular standard applies to the IDAHO4. But all right, we'll move on to the next standard, which is 2.4, collecting DNA samples from persons in a group by consent. A law enforcement officer should be permitted to obtain a DNA sample from a person by consent. except that consent should not be sought from persons based primarily upon their membership in a constitutionally protected class. Consent should be sought from a large number of persons based on grounds other than individualized suspicion that each committed the crime under investigation, unless seeking such consent has been authorized by the head of a law enforcement agency or the chief prosecutor in that jurisdiction. And when consent is sought as provided in subdivision B of this standard, each person should be informed of the reason for the request and of the right to refuse it, and the consent should be obtained in writing. Standard 2.5. Manner of collecting and preserving DNA evidence. Okay, so this could definitely be very relevant for this case. DNA evidence should be collected and preserved in a manner designed to document its identity, ensure its integrity, and whenever possible, ensure its availability for testing and retesting. Well, as far as we know, the DNA that they collected is not available for retesting. Very strange. The evidence should be properly handled, packaged, and labeled and stored. And the location where the place, thing from which the evidence was located, or the person from whom the entity from which it was collected, the date and time it was collected, the identity of the person who collected it, and manner in which it was collected and preserved should be documented. 100%. It's all about document, document, document. It needs to be labeled. It needs to have the location or the place where the evidence was found, the person who collected it, the date and time of that person who collected it, the identity of the person who collected it, and the manner in which it was collected. And that's just the bare minimum. I'm sure there's some other things that go along with that, but every time the sample moves or somebody looks at it, that person needs to have their name and the date and time on it. So whenever DNA evidence is collected from a person, it should be collected by a method that is medically safe and no more intrusive than reasonably necessary. When it is collected from a person by a court order, the order should so specify property containing DNA evidence obtained in and in the investigation of an unsolved homicide, rape, or other serious offense, and the extract from such evidence, if any has been obtained, should be retained in a manner that will preserve the DNA evidence. A jurisdiction should promulgate written rules in all cases which should require authorization of the prosecutor before the property or extract is destroyed or discarded. Do you think, we've heard that there isn't any biomaterial left. Do you think there's any documentation stating that? I think that's important as well. And I do think that is part of chain of custody. But I'm not 100% on that. But, I like documentation, so I would include it in my information packet if I was putting together this report. Property containing DNA evidence obtained in an investigation which has resulted in the prosecution of a person or persons for homicide, rape, or other serious offense, and the extracted from such evidence, if any has been obtained, should be retained in a manner that will preserve the DNA evidence until all persons charged have been convicted of an offense. And adjudicated as having engaged in conduct constituting such an offense and have exhausted their appeals and served their sentences or commitments. Right. I think that document for how the biomaterial was discarded or destroyed, whether it's because they run out after testing, whatever, that document I do believe is important because the biomaterial is supposed to be preserved all the way through all of the appeals and after the person serves the sentences. It's supposed to be present and accounted for. So if retention of a particular piece of property containing DNA evidence is impractical, reasonable care should be taken to retain representative samples of those portions of the property that contain the DNA evidence. All right, I'm going to come back here, see what the chat is saying. Hello, Joanna, welcome. And Joanna says, Anne hinted at the change of venue hearing about amendments, overreaching certain procedures, how he was not a fugitive either. Yeah, that's correct. He was just going home for break like all the rest of the students. Yeah, I agree, Christina Vada. That would be very nice if they would unseal everything. So now we're on to part 3, the testing of the DNA evidence. Standard 3.1, testing laboratories. Immediately that comes to mind is that wasn't there a subpoena or a search warrant for a forensic lab? Was it the Coeur d'Alene forensic lab? And is it sort of strange that one department is using warrants or subpoenas for a lab, and presumably that lab did testing for the investigation? I don't know. I would like to hear more about that warrant. Yes, it was one of the warrants. It was one of the forensic labs. I thought it was Coeur d'Alene, but I could be wrong. So testing laboratories. A laboratory testing DNA evidence should be accredited every 2 years under rigorous accreditation standards by a nonprofit professional association actively involved in forensic science and nationally recognized. At the time, Ortham Labs was not accredited by whichever, I forget the name of the accrediting body. I think Ortham has some accreditation, but I don't know if the Department of Justice recognizes that accreditation. But whatever accreditation Ortham had at the time, I don't know about now, whatever they had at the time was not recognized. The accrediting body was not recognized by the Department of Justice. Be governed by written policies and procedures, including protocols for testing and interpreting test results, and permit deviation from protocols only by a technical leader or other appropriate supervisor. Use quality assurance and quality control procedures, including audits, proficiency testing, and corrective action protocols. This is what Ann Taylor had requested in one of these motion to compels, is the corrective actions. And I remember that Judge confused it, and he said something about, like, I forgot what he said, but he confused what it was. But yes, she was asking about that. And when we read a few videos ago, we read the Alabama lawyer. It was from the American Bar Association, alabama.org website. She was saying, yes, on cross, you want to ask these analysts all of these questions about their procedures, how they do things, their audits, their proficiency testing, their corrective action protocols, what kind of things they do. You know, you want to get into the nitty-gritty so that the jury and the attorney could fully understand what happened to that biomaterial sample while it was in their possession. And I know a lot of people out there were like, well, Anne's asking for way too much. No, apparently this is what they do, and it's right here in another American Bar Association document, that these testing laboratories should have these, and attorneys do ask for them, that are consistent with generally accepted practices and in writing. Use protocols for testing and interpreting DNA evidence that are scientifically validated through studies that are described in writing. Follow procedures designed to minimize bias when interpreting test results. Timely report credible evidence of laboratory misconduct or serious negligence to the accrediting body, and make available to public the written material required by this standard. A laboratory testing DNA evidence should make available to the prosecution the information and material that the prosecutor must disclose to the defense pursuant to Standard 16.4.1, and to defense counsel the information and material that the defense must disclose to the prosecutor pursuant to that standard. When an accrediting body receives notice of credible evidence of laboratory misconduct or serious negligence concerning DNA evidence at the testing laboratory, either as provided in subdivision A6(bi) of this standard or through other means, it should audit laboratory procedures and cases that may have been affected by misconduct or serious negligence and issue a written report. Let's come back to chat and see what you're saying. Meg P, welcome. Oh, Sarah D. Irish is in the house. Very welcome. Thank you. Thank you for picking up this article. Much appreciated. Thank you. Oh, you bring up a great point, Misty. Misty says, oh, why is the press not speaking about the 3 unknown male DNA? Does anyone think there are things going on in the background that won't get released till just the right time? I do. Yeah, I agree. I agree with that. Right. The status. Commercial started asking about what are the status of the 3 unknown DNAs. Oh, thank you, Sarah D. Irish, for confirming that it was a search warrant was for the Coeur d'Alene Police Forensic Lab dated the 1st of November, the 1st of December 2022. Wow, thank you. That's so great. Perfect. Oh, and yes, look, I heard about this commercial zone that the Coeur d'Alene lab had a fire recently. I think that's sus as well, in my opinion. Let's see, did I miss anyone? Okay. So, Standard 3.2, testing and interpretation of DNA evidence. DNA evidence should be tested and interpreted in a timely manner by qualified personnel using the policies and procedures adopted by the laboratory as provided in Standard 16.3.1. That reminds me. I believe it is the protective order, the motion for protection of the IgG filed by the state. They're very unclear on when the DNA from the sheath was tested. Let me see if I can bring that up. Because they said something like, here it is, on December 28th, and they made it sound like they were both tested at the same time. All right, so here's the motion for protective order. Am I on the right screen? Yes. Yes, I agree, Clopenny. Discussing them doesn't fit the order or the narrative that BK is guilty. Yeah, I'm not sure if they received it either. That is true, Misty. The feds are buzzing around this case. Okay. Oh, is it this one? It might not be this document. It might be in response. Or, is it the PCA itself? Because here's the exhibit of Brett Payne. It says here, that evidence was sent to the Idaho State Lab for testing. Okay, so they collected the trash from the Coburger residence on December 27th. And then they sent it to the Idaho State Lab. Okay. And then on December 28th, the Idaho State Lab reported a DNA profile obtained from the trash and the DNA profile obtained from the sheath. Now, that sentence to me means the Idaho State Lab just recognized, okay, there's a DNA profile here on here. There's a DNA profile on here. That doesn't say anything about a result. But then he smashes this sentence at the end of it. But this is unclear. Is it for both of them? Is it for one of them? Or is the trash that you tested from the Pennsylvania trash that identified a male as not being excluded as a biological father? So that's unclear. And if that's true, do we know when the STR profile was created from the sheath? Because this makes it seem like it was on the 28th, and if it was, what was it doing for all that time? So Christy Nevada says, I do feel we will all be surprised when it all does come out, no matter who did this. There's more going on in that town. I would agree. Yeah, I would agree. Let's see. What other... I don't think... Here is the motion for protective order. And I don't know if they give a date for that sheath. No, I don't see it. Okay. What else do I have up here? I have Ann Taylor's declaration. Maybe she has the date in the beginning. Oh no, this is Becca Barlow. Maybe she has it. I'm not sure. You think the 20th of November? Yeah, that sounds about right. Thank you, Sarah the Irish. So that was at the STR profile. One of the profiles was, it's in the objection to the state's motion. Right, okay. That's what I thought. Thank you, Chloe Penny and Sarah the Irish. Oh, Misty says on the 28th. No way could LE determine who touched that trash, considering there were females also in the family home. True. They arrested BK 2 days later by some miraculous results. Absolutely miraculous. Sorry, I don't find it either. Commercial Zone says, if the PCA is a guide for how they document, can we only imagine what these DNA cases notes looks like? Oh my gosh, you have a great point. You have a great point, Kathy. Oh my gosh. Oh. Um, uh-oh. I've lost connection to screen share. Can you all still see it? Chloe Penny with the facts. Here we go. Yes, it's in the objection to the state's motion for protective order, the STR profile. Yes, more facts. You guys are great with the facts here. Commercials is so funny. Asking BP to be clear is asking too much. Oh, yeah. Thank you, Sarah the Irish. I'm glad you guys could see this. I'm trying to get this page here. Okay. Well, this last one here for where did we leave? I'll just read the testing for testing and interpretation of DNA evidence. DNA evidence should be tested and interpreted in a timely manner by qualified personnel using the policies and procedures adopted by the laboratory as provided in Standard 6.16 3.1. Each step in the testing of the DNA evidence and in interpretation of the test results should be recorded contemporaneously in case notes. The case notes should document all information necessary to allow an independent expert to evaluate the process used and the conclusions reached. All case notes made and raw electronic data produced during testing should be preserved. That's another one of those weird things. Even though it is FEMA pressure, the IgG, still, because the defense is asking for it, it all should be discoverable, and they should have all of the notes. They should have all the raw data. They should have all this. That's interesting. Okay, so Commercial Zone says, remember that Kevin F. article on the FOIA docs. He said the invoice for Ortham was $11.29-ish. Wouldn't that have been after ISP? So I think I know of Kevin F. Is he one of those guys that is on Twitter? I see people sharing his articles or like correcting his articles. But is he the one responsible for getting that receipt from Ortham? Chloe Penny says, yes, must be around that time they started the IgG work. Okay, right. Well, so if they don't plan to use the IgG, right? So there will be a gap. There will be static between the time when they collect the DNA from the crime scene to when the actual STR is created. So I do believe they're going to need that for chain of custody issues, because then if they act like it doesn't exist, then my question would be, how many weeks went by? So like what was law enforcement doing between when they found the DNA at the crime scene and when they actually made the STR profile on December 28th, the day before the arrest Brian Kober? That's a long time, from November 13th to December 28th, or however long that is. And so I think it will be beneficial for everybody to have that IgG information available to the jury as well, so we can see from start to finish how this DNA interpretation went. He works for the Idaho Statesman. Thank you, Chloe Penny. So in the Kevin C. FOIA docs that Kevin C. Kevin F. from Twitter, from the Idaho Statesman, He's the one who FOIA-docked the Orthom Lab receipt, which I have shown before. I'm not sure if I have it up here. I can show that if you all want to see it. So if they started their work on the 11/29th, it seems like ISP would have worked on that sheath before. Yeah. As soon as you see that sheath, it should have been in chain of custody, already have documentation on it before it even gets to the lab, but then you want to put, you want to quickly and as professionally as you can get that to the lab. Commercial Zone says, here is another sus point to me from 11/29. Within 30 minutes of each other, 2 WSU cops just happened to come across BK's car. The coincidence of this case are wild. Right. What do they call that? The suspension of disbelief. There's just too many. There's just too many. Clip Penny says they got the DNA from the sheath on the 20th and made the STR profile then. Okay. So that would be 7 days from November 13th to the 20th. Now, am I remember correctly when Brett Payne said he found the sheath on the second walkthrough? Was that 3 days later on November 16th? I'm not sure where I got that information from, but I feel like that is something that I was told. Right. So let's just say, for argument purposes, isn't the jury going to wonder, what did you do? What did you do with the DNA from November 13th through November 20th? No, I read it as they found it on the November 13th. Okay, Chloe Penny. Thank you for confirming that. All right. Right. Awesome. Okay, where were we on here? Here we go. We are on to the next one, 3.3, laboratory reports. A summary of all DNA testing and data interpretation should be recorded promptly in a report. Oh, we know MPD didn't do that. There's 3 unknown male DNAs out there somewhere. The report should be sufficiently comprehensive so that an independent expert can identify the process used and conclusions reached. Specifically, the report should include what was tested, who conducted the testing, identification of protocol used in the testing and any deviation from the protocol, the data and results produced by the testing or data interpretation, the examiner's interpretation of the results and conclusions, their form, the method and results of any statistical computation, and any additional information that could bear on the validity of the test results, interpretation, or opinion. A separate section of the report should explain the test results, interpretation, and opinion in language comprehensible to a layperson. Well, they don't really explain the likelihood ratio very well. So I think that forensic DNA experts could explain that a little better. But, of course, the state doesn't want them to, because then the likelihood that the DNA matches whatever defendant goes down. Consumptive testing, standard 3.4. Okay. Commercial Zone says, here's another sus to me point from 11:29 within 30 minutes. Oh, sorry, I read that one. Sarah D. Irish. The 20th of November is when the STR profile was obtained and uploaded to CODIS. Okay. 9 days later, on the 29th, is Ortham's invoice. There you go. See, there's a gap in time right there. I don't know if, like, see, for me personally, a gap in time and DNA puts up red flags for me. So there's missing days there. Like, where was the sheath and the DNA for 9 whole days? Commercial Zone says he's a writer with the Idaho Statesman, Kevin Fischler. Okay, yeah, I've seen him, and that's excellent that he got the receipt from Ortham. Commercial Zone, sorry, they can't pretend they didn't use the sheath. It's discussed in the PCA plus line 1 on the order on defense IGG motion to compel. Paragraph 1 says FBI told local authorities, look at BK. Right. And to me, the state's motion for protection order of the IGG, it never really states they knew what the FBI did with it. It really just says, to their knowledge, they don't know. But if they were going to know, this is what they assume the FBI did. And so without hearing from the FBI, how do we actually know that the FBI did anything? And is it two different things for FBI to have conducted IGG of some sort, and then for them to have named a person or a tip? Because in reality, those could be two separate things, even though they did both things. And that is another one of those things that we should be aware of with Bill Thompson's writing style, because he does that. Even in the protective order for the IGG, it describes the physical action of a STR analysis. It doesn't say anything about an STR analysis matching Brian Kohberger. See, and that's another example. There's a physical action of actually doing an STR analysis, and then there's another physical action of actual results or statistics or something that is related to that other action. How did the FBI know to look at BK? Right? How? That's $1 million question. BP says something like, on further review, the sheath was visible from the door, but he's escorted to MM's room by one of 3 cops, first at noon. Did they both miss it? That is an excellent point. So not only are there questions of police actually on the scene not being able to see the sheath, but the actual police that document the sheath can't agree on where it was located. That is not good. All right, let me continue reading here. When possible, a portion of DNA evidence tested, and when possible, a portion of any extracted from the DNA evidence should be preserved for further testing. A laboratory should not undertake testing that entirely consumes DNA evidence or extract from it without prior approval of the prosecutor if a law enforcement officer is requesting the testing, or of the defense counsel if the testing is required by defense counsel or defense counsel's agent. Before approving a test that entirely consumes DNA evidence or the extract from it, the prosecutor should provide any defendant against whom an accusatorial instrument has been filed or any suspect who has requested prior notice and opportunity to object and move for an appropriate court order. Before approving a test that entirely consumes DNA evidence or the extract from it, the attorney for any defendant against whom the accusatorial instrument has been filed for any other person who intends to conduct such a test should provide the prosecutor an opportunity to object and move for an appropriate court order. If a motion objecting to consumptive testing is filed, the court should consider ordering procedures that would permit an independent evaluation of the analysis, including but not limited to the presence of an expert representing the moving party during evidence preparation and testing, and videotaping or photographing the preparation and testing. Pretrial proceedings. Standard 4.1, disclosure. The prosecutor should be required within a specified and reasonable time prior to trial to make available to the defense the following information and material relating to DNA evidence. Laboratory reports as provided by Standard 16-3.3. If different or not contained in any laboratory report, a written description of the substance of the proposed testimony of each expert, the expert's opinion, and the underlying basis of that opinion, the laboratory case file and case notes, a curriculum vitae for each testifying expert and for each person involved in the testing. The written material specified in Standard 16.3.1a, testifying expert and each person involved in testing with further information on proficiency testing discoverable on showing of particularized need. The chain of custody documents specified in Standard 16-2.5, all raw electronic data produced during testing, reports of laboratory contamination and other laboratory problems affecting testing procedures or results relevant to the evaluation of procedures and test results obtained in the case and corrective actions taken in response, and a list of collected items that there is reason to believe contain DNA evidence but have been destroyed or lost or otherwise become unavailable. Material or information within the prosecutor's possession or control, including laboratory information or material that would tend to negate the guilt of the defendant or reduce the punishment of the defendant. That's interesting that Bill Thompson didn't do any of that. For the 3 unknown DNAs, which I do believe that's exculpatory, and it can negate the guilt of the defendant. So they didn't even provide that. Wow. Okay, so last one here for this section. The defense should be required within a specified and reasonable time prior to trial to make available the prosecution, the information and material in subdivision AI through 9 of this standard for each expert whose testimony the defense tends to offer. Standard 16.4.2, defense testing and retesting. Upon motion made with notice to the prosecution, a court should permit the defense to inspect and test DNA evidence in prosecution's possession or control. An affidavit in support of the motion may be presented to the court ex parte. That was cool. Didn't know. The motion should specify the nature of any test to be conducted, the name and qualifications of the expert designated to conduct the test, the place of the testing, and the evidence upon which the test will be conducted. The court should issue any orders necessary to make the evidence to be inspected or tested available to designated expert and condition its order as to preserve the integrity of the material to be tested or inspected. Prosecution monitoring of the preparation and testing should not be permitted unless consumptive testing is involved, as described in 16.3.4. All right, let me see what the chat is doing. Joanna says, Payne Blaker are always cop partners. Nina Smith are. Gunderson Snyder are. Which partners went first in the crime scene? This could be one key evidence for the defense, but I have to do research more. That is an excellent point. That is very good to know. I didn't know that. And that makes sense because, police usually have partners. And so that would make sense as to why Nunez and Smith, they were the first on scene, right? Interesting. That is a very good point. Thank you for sharing that. Commercial Zone says, J.J. Long, 1025-23 order on defense motion to compel says FBI was working on family tree. That's when they told local authorities to look at Brian Kohlberger. First paragraph, 1025-23 order. Commercial Zone says, Joanna, per Bloom, it was Nunez Smith on duty. Gunderson, the sergeant, decided to go as well. Oh, okay. Joanna says, nobody goes alone. Misty says, also, how did BP know instantly it was KG in MM's room since she wasn't meant to be there? Great question, Misty. They had to ID Xana from her purse. KG could have been anyone else of Maddie's friends. How did they know? That is a very good question, sorry. Yes, it was the three, Nunez and Smith plus Sergeant Gunderson. That is very good to know too. Thank you, Kathy. Commercial Zone says, Bloom's airmail article today was interesting, although I don't agree with a lot of what he says. He said Ortham was working on the family tree, then the FBI took over, according to Bloom. Yes. Okay. That's sort of how that is presented in the motion for protective order. Okay, so standard 4.3, defense experts. Expert assistance should be provided to indigent defendant at government expense prior to and during trial if there is reason to believe that the prosecution will present DNA evidence or if expert assistance may lead to the discovery of relevant evidence. The defendant should be permitted to make an application for expert assistance ex parte. Wow. That is interesting to me that the defense has some rights to do things ex parte. Or maybe that is just protocol, that these are standard documentations we're going to send to the court. They're going to fill it out. I don't know how that works, but I do think that there are built-in ex partes for the defense rights when it comes to this DNA. Very interesting. If the expert will not testify as defense witness at trial, the prosecution should not be permitted to interview or call the defense expert as a prosecution witness unless the court determines that the prosecution has no alternative means to obtain equivalent evidence that expert possesses. Part 5. trial. Standard 5.1. Admissibility of DNA evidence. Expert testimony concerning DNA evidence, including statistical estimates, should be admissible if based on a valid scientific theory. Interesting. I personally have been attacking the state scientific theory. So, and that statistical number that they use, I do believe is invalid. So I am curious. I'm so curious to see what's going to happen to that statistic. I have a feeling it's not, that statistic won't be admissible, but I don't know for sure. That's just my opinion. A valid technique implementing that theory and testing and interpretation, properly applying the theory and technique. A court should be permitted to take judicial notice of facts relating to DNA evidence that are not subject to reasonable dispute. A witness testifying about DNA evidence should be qualified by knowledge, skill, training, or education in those matters about which that witness testifies. Whenever feasible, issues involving the admissibility of DNA evidence should be determined prior to trial. Yeah, so, well, like Kathy from Commercial Zone says, I do also believe a motion to dismiss will be coming up, but in the same notion, we will know prior to trial what DNA evidence will and will not be admissible. And I also want to say again, just because the state says they're not going to use IgG, they're only going to use the STR profile that happened after the arrest, the buccal swab, doesn't mean that's actually set in stone. We don't know what's going to happen to that yet. And people are taking that as fact. And, you know, if you look into the DNA just a little bit, dig into it, you might realize that that statement might not actually be a true one. Or we don't know the outcome of it yet. Standard 5.2, trade secret privilege. Oh, this is one of my favorite ones because California, I don't know, last 5 years, I can't remember, there were 2 politicians that helped write into law that these private labs weren't able to black box their proprietary information because the defense has no way, absolutely no way to defend themselves against these private labs that say, well, we can't tell you how we do things because that's our proprietary work product. So at least there's California. I'm hoping that states like Maryland, Montana, and Utah, the states that have implemented those laws for the IgG, which Stephen Mercer from one of those motion to compel hearings, the DNA hearing in the Koberger case, he lives and works in Maryland, and he helped implement those laws, how to present and use IgG in trial. I'm hoping that states that feel in that similar vein also adopt things like this, because it's completely unfair that defendants have been they haven't been able to defend themselves against DNA for as long as it's been in existence. And this is another one of those things where the public doesn't quite understand what DNA is, so it becomes even harder for a defendant to defend themselves. And as we've learned up until now, there have been forensic DNA evidence that have been lying on their reports and matches. You know, it's been on the news that one of these DNA forensic experts that has thousands and thousands of cases have done it incorrectly. So these trade secrets, this should be a hot topic. I'm hoping it's the next hot topic because after this case, I think the states are going to start discussing how they want to go forward with IgG, whether they want to model like Maryland. I know the Department of Justice has also published their policies, which we went over in a live, or and how it is very similar to how Maryland has set up theirs. I do think other states will slowly start following suit, and hopefully this is the next subject that they tackle. So, trade secrets privilege. The successful assertion of the trade secrets privilege should not relieve the proponent of DNA evidence of the obligation to satisfy the admissibility criteria, standard 16-5.1. A trade secrets privilege should be recognized if the allowance of the privilege would not tend to conceal fraud, prevent the proponent of DNA evidence from satisfying standard 16-5.1, unduly interface with the ability of a party to challenge the admissibility of the evidence or its reliability, or otherwise work an injustice. When disclosure is directed, the judge should prescribe such protective measures as furtherance of justice may require. Standard 5.3, presentation of expert testimony. Let me just come back to chat to see what you are saying. Misty says, anyone else think BT or Bill T will retire before trial and allow Miss Beatty to take over? I have a feeling his outburst a couple of hearings ago has made it worse for the prosecution. I would agree with that. Yeah, Beatty seems more capable. Well, maybe not more capable, but she seems more focused. I don't know. I think Bill Thompson really hurt their case. He hurt it so much to the point he had to admit in their last motion that they don't really know where Brian was. They know he was in proximity to a cell tower. A cell tower that provides service to the crime scene. But that's everybody in the area. Anybody can be near a cell tower at any given time. So yeah, I do believe his outburst was the day they lost the trial, but that will remain to be seen. Let's see. Christy Nevada says, I do think that too, but he can retire in the middle of his case. Yeah, I think he'll retire, especially if it saves some of his reputation. I mean, he can do, I guess, whatever he feels. I don't know for sure, though. Commercial Zone says, Captain Lanier retired in June when the trial was supposed to be in October 23. That is true. Followed by Chief Fry earlier this year. Maybe BT will follow suit. I have a feeling yes. Misty says, meant to say Miss Beatty. I think if he wants out, then yes, he could. Look at how many have bolted from this case already. Yeah, it's noticeable for sure. Christy Nevada says, true, I forgot about them all retiring. So let's see if he follows. And I bet he retires also. I agree, Commercial Zone, says Misty. The ship is sinking. For sure. Oh, Chickbait! Welcome, everybody. Welcome. So good to see you, Chickbait. Aw. I don't know if you've all seen Chickbait's recent video. It is excellent. Very good. You should definitely check it out. Wow, my computer is slow. I probably have. Uh-oh. Now it says Chrome isn't responding. All right, let me give it a minute. I know that I just learned about the ex parte that the defendant is entitled to when it comes to the DNA evidence. But I'm curious to know how much ex parte communication Bill Thompson has had with Judge. I do believe it's a norm there that's what they do. Because, sometimes small towns, they can have kind of like rules of their own. And we know the one time where it was obvious, Ian Taylor called them out. I agree with you, Sheik Bait. The defense is entitled to a fair trial. They are setting this up, in my opinion, to get BK to sue. Do you mean that they're trying to set it up so BK sues, or that's just going to be the natural outcome? All right, everybody, I have found Sheik Bait's YouTube. Very good. All right, let's go on to standard 5.3, presentation of expert testimony. An expert giving testimony concerning DNA evidence should be asked to identify and explain the theoretical and factual basis for any opinion given and the reasoning upon which the opinion is based. Expert testimony should be presented to the trier of fact in a manner that accurately and fairly conveys the significance of the expert's conclusions. Valid statistical estimates of population frequencies should be admissible. Well, we had one, the octillion one. The jury's out on that. Is octillion a valid statistic? I don't think it is, because our population isn't octillion. I was reading about databases, I don't know, sometime this week, and there is something that they do where if they're looking in multiple databases, that they can multiply by how many people are in that database. But still, people shouldn't be in there twice, or more than once. So even if you are doing database searches, you should, well, is it possible to have more DNA profiles in a DNA database than there are actual population sizes? I don't know, but somehow when they use multiple databases, they are able to multiply by how many people are in that database in the process of that mathematical equation that they use for the statistics. I don't know where, but where in that formula it goes, but I thought that was interesting that when they are calculating databases, they also use math and statistics as well. So when DNA evidence is offered at trial, evidence relevant to the reliability of the evidence, including relevant evidence of laboratory error, contamination, or sample mishandling, should also be admissible. And I think this is another one of those things where when you are doing cross-examination of the state, their forensic experts, I would want to ask about that. I would want to know about that. And so I would want that discovered just like Anne. So an attorney intended to call an expert witness concerning DNA evidence should confer with that expert in preparing for trial in order to permit an informed and appropriate presentation consistent with the standard. All right, standard 5.4, prosecution comment on defense response to tests. A prosecutor should be permitted to argue or imply that a defendant's failure to test or retest DNA evidence, or the defendant's failure to offer evidence such as a test or retest conducted on the defendant's behalf constitutes a submission of guilt. Oh, they should not be permitted to do that? That's good to know, because I'm pretty sure that we're going to be hearing about something to that nature from the state. So I'll repeat that. A prosecutor should not be permitted to argue or imply that a defendant's failure to test or retest DNA evidence, or defendant's failure to offer evidence of such a test or retest conducted on the defendant's behalf constitutes an admission of guilt. All right. A prosecutor should be permitted to offer evidence or make argument concerning the defendant's failure to test or retest DNA evidence, or defendant's failure to offer evidence of such a test or retest conducted on defendant's behalf only for a purpose other than an admission of guilt, and only in fair response to evidence or argument of the defense. The court should instruct the jury that it may consider that evidence only for that purpose. Okay. Part 4, post-conviction. Standard 6.61.1. Post-conviction testing. A person who has been convicted of a serious crime, including a person convicted based on a guilty plea, should be permitted to have DNA evidence in the possession of the prosecution or one of its agents tested or retested after conviction if the testing requested was not available at the time of trial and currently is available from a laboratory meeting the requirements of standard 16-3.1. There is credible evidence that prior test results or interpretation were unreliable, or the interests of justice require testing or retesting, and the results of testing or retesting could create a reasonable probability that the person is innocent of the offense. In a capital case, did not have the culpability necessary to subject the person to death penalty, or did not engage in aggravating conduct that caused a mandatory sentence or sentence enhancement. When a person files an application for testing, retesting, the prosecution should be notified. If the person is indigent and does not have counsel, counsel should be appointed. So I had a thought. The results of testing or retesting could create reasonable probability that the person is innocent of the offense. So what happens if, like, the state fights to have those 3 unknown DNAs inadmissible so that the jury can't hear about them? Can Brian Kohberger come back on appeal and say, yes, it is on record in my pretrial motion at the motion to compel for DNA or whatever hearing that was, that there are, in fact, 3 unknown DNA profiles in this case? I wonder if Judge is going to have to allow those in for that purpose of appeal. But I don't really know how that works, but I think that's going to be an interesting piece no matter how it's played here. So when a person files an application for testing or retesting, an indigent and does not have counsel, counsel should be appointed. The application should be denied unless the person, after consultation with counsel, files a sworn statement declaring that he or she is innocent of the crime, did not have the culpability necessary to be subject to the death penalty, or did not engage in the aggravating conduct that caused a mandatory sentence or sentence enhancement. If the person files the statement, a hearing should be held to determine whether the person has met the requirements of subdivision of this standard, and if their determination that the requirements of subdivision A of the standard have been met, the request for the testing or retesting should be granted. After the results of any testing are reported to the parties, the applicant should be permitted to seek a second hearing to determine what relief, if any, is appropriate, and if either is to be held, the prosecutor should be required to give prior notice of the hearing to the victim of the crime to which the hearing relates. If the application for testing or retesting is granted and the court determines the result is inculpatory, the applicant's profile should be entered into the database authorized in Standard 16-8.1 BI of if it is not already present there. An applicant should have the right to appeal or seek leave to appeal any adverse decision made pursuant to this standard. Interesting. Let me see what you all are saying over here in chat. Okay. Chic Bait says, no, I don't think BK is in a good position to sue. No, I think BK, the prosecution doesn't care. Okay, so he is in a good position to sue. It's 5th grade math, right? So did they find the 9 knives? No. No. The law enforcement does not have the weapon. And even if they did, the way that the state has been leaking things to the mainstream media, I'm sure somehow that would be leaked. Yeah. Sheikbait says it's going to be inadmissible if they can't prove it. Oh, what? The 3 unknown DNAs? Or the sheath? Cassidy Kane, welcome! Cassidy Kane says, it's really odd to me that the only sample that was able to be or was sequenced was the BK sample. I would think there must have been tons of DNA. I agree. It was a party house. For one, DNA all over, people in and out, and the proximity of some of the victims to the object. I would think it would be a mixed profile. Oh, Shikbi, yes, I did. I watched your video. Yeah, if they're going around the neighborhood asking people if they can be unbiased, and people just being like, yeah. Like, if you are a resident of Moscow and somehow you're in the presence or you're confronted by a victim's family and they're asking you, can you be unbiased? I can't imagine being in that position because like the victim's parent is like right in front of you. Ugh, it's just terrible all the way around. It was a News Nation interview. I'm not surprised it was News Nation. The things that they allow on News Nation. All right, let's go to charging by DNA profile, the part 7, standard 7.1. Charging persons by DNA profile. When DNA evidence that may have been left by the perpetrator of a serious crime is collected and preserved, a DNA profile of the person who left the evidence is established from it. But the person's identity is unknown. A grand jury or prosecutor should be permitted to charge the person as identified by the profile with the crime by indictment or other instrument requiring a judicial probable cause determination. Okay. Part 8, DNA databases. Standard 8.1, authorized and proscribed DNA databases. The legislature should authorize the establishment, maintenance, and operation of DNA databases used for criminal identification and prescribe DNA databases that are not statutorily authorized. The legislation should include significant criminal and civil penalties for unauthorized databases and for unauthorized use or dissemination of information from any database. The only databases permitted to be maintained for criminal identification purposes should be those including profiles of persons convicted of crimes designated by the legislature as appropriate for inclusion in the database of persons found not guilty by reason of insanity for such crimes, and of persons adjudicated for conduct that, but their age constituted the commission of such crimes, or of persons arrested for crimes designated by the legislature and appropriate for inclusion in the database. If there has been a judicial determination of probable cause or an indictment or information that has been filed derived from the evidence collected from the crime scenes or other locations as provided in Standard 16-2.1 and maintained for quality assurance at a laboratory. A genetic profile should be included in the database only if developed by testing conducted as provided by Standard 16-3.2. Whenever a matching profile is declared, confirmatory retesting of a new sample should be conducted if possible. So, I don't think the confirmatory testing was done. I mean, I know we've already heard that the biomaterial wasn't enough for the retesting, but for some reason the way the state words things, I don't think that happened. All right. Databases should be developed and maintained in a manner that protects privacy to the fullest extent possible. Specifically, to the extent feasible, DNA markers valued only for individual identification and not known to be associated with behavioral propensities and susceptibility to disease should be used. Each profile should be maintained by number or by another anonymous means, and the information identifying a profile as belonging to a particular person should be separately maintained and safeguarded. Profiles should remain anonymous unless a matching profile is declared. Reasonable steps should be taken to prevent unauthorized access to, tampering with, or copying of the contents of the database. DNA samples used for the purposes of developing profiles of unknown individuals should be retained only for the purpose of confirmatory retesting or for upgrading the database to reflect new technologies. Databases should be expanded to other categories of persons as resources become available. Privacy concerns are resolved and the security of the information is assured. Use restrictions and destruction of DNA evidence, Standard 8.2. All right, let me see what you all are saying in chat. Chic Bait, I heard it first on Truth and Transparency. Yes, I watched that one too. I'm totally not biased. Thanks for the interview. Right. It was wicked. Wicked is a Massachusetts slang. I know, I was just gonna say. Is that's so funny. Wicked. This is why BK's first attorney in PA was saying he was looking forward to be exonerated. I would agree with you, Sheik Bait. The prosecution is ignoring the facts. Right. I would say tunnel vision, not only for Brett Payne, but for Bill Thompson as well. I think this is going to be his last case regardless, and so he wants to look good. I mean, who wouldn't? So I do think there's some tunnel vision there too, but that's just my opinion. Use restrictions and destruction of DNA evidence. A profile developed from DNA evidence collected as provided in Standards 16-2.2 and 16-2.3 should not be entered into a database or compared with profiles in a database, for example, by keyboard search. If a profile developed from a DNA evidence at a crime scene or other location as provided by Standard 16-2.1 has been identified as that of a person who is not a suspect, that profile should be entered into a database or compared with profiles in a database. Oh, it should not be. Wait a minute. I think we've got something here on Standard 16-8.2. Use and restriction and destruction of DNA evidence. B. If a profile developed from DNA evidence at a crime scene or other location as provided in Standard 16-2.1 has been identified as that of a person who is not a suspect, that profile should not be entered into a database or compared with profiles in a database, for example, a keyboard search. So I'm a little confused about some of what just a second. I'll be right back. Give me just All right, thank you about that. Okay. So we were okay. Now, something is weird about standard. I'm not on mute. Okay. Standard 16-8.2 use restrictions and destruction of DNA evidence. B. If a profile developed from DNA evidence at a crime scene or other location, as provided by Standard 16.2.1, has been identified as the person who is not a suspect, that profile should not be entered into a database or compared with profiles in a database. For example, a keyboard search. I'm still a little confused about. So I know in Becca Barlow's declaration, she talked a lot about cold hits and the DMP, which is the database database match probability, the DMP. So whatever database may or may not be used in this case, it wasn't CODIS, because they already said that there wasn't any matches to CODIS, but there are other databases. DNA database now is IgG, those are like genealogical databases. They're not necessarily DNA databases, are they? Or do they have like the family tree part and the DNA part? Is that considered a DNA database? So when they're saying crime scene evidence or other location could be a DNA database. I don't know. I'm just thinking out loud here. I'm going to put a bookmark in B. I think that could use a little bit more thinking. All right. C. A profile developed from DNA evidence collected by consent as provided by Standard 16-2.4 should not be entered into a database or compared with profiles in a database, for example, by keyboard search, without written consent of the person who is the source of the profile. Now, is that in any relation to the privacy for those IgG websites? Because remember, there was that hearing about people who opt in and out. I'm not sure if these apply to that or not, but I'm just drawing connections that may or may not be there. Okay. A profile developed from a DNA sample collected from a location other than a crime scene solely for the purpose of obtaining a profile of a person should not be entered in a database. Is that like because they obtained Brian's dad's DNA from his trash? So Brian's dad's DNA, if it's not already in CODIS, should not go into CODIS. Is that what that means? I'm not too sure. What do you guys say? It's about how you collect the DNA, not how you volunteer it. Okay. They can use the touch DNA from the nice sheet. Okay. Thank you for that, Sheik B. All right. Where were we? D. A profile developed from a DNA sample collected from a location other than a crime scene solely for the purpose of obtaining the profile of a person should not be entered into the database. E. When the official investigation or prosecution is concluded and it is determined that a previously unknown source of DNA evidence was either a victim of the crime that is under investigation or that is the subject of the prosecution, or any other person not related to the crime as a perpetrator, the evidence should be destroyed and any profile developed from it should be expunged from any DNA database into which it had been entered. Right there, that seems like another one of those confusing arguments Bill Thompson would make. Where they found 3 unknown male DNA profiles at the scene. They could have been suspects, and why not? But I'm sure when Bill Thompson gets a hold of that, he could argue this point. But the problem is, he personally does not know whether those 3 unknown sources of DNA could have been a perpetrator. I would say yes, especially in a crime like this, those should have been looked into. So, but that's what I'm talking about. I hope, if you guys haven't seen Kuhar Lucher's video on Bill Thompson's Palter about his argument and writing style, you definitely should. He likes to confuse things, and he did a really good job of it. And the motion for protection order of the IGG, and he had something to do with the PCA and why it's written that way. So, F, a profile developed from a DNA sample collected from the remains of an unidentified deceased person may, for the purposes of identifying that person, be compared with profiles in databases authorized in Standard 16.81b, but should not be entered into a database. Notwithstanding the provisions of the subdivisions A through F, a laboratory conducting DNA testing should be permitted to enter in a quality assurance database maintained by the laboratory any profile developed from DNA extracted in the testing conducted in the laboratory, as should be permitted to retain the profile in that database as long as necessary for quality assurance purposes. Standard 8.3, access to DNA databases. Information in a database should be provided only to criminal justice agencies and only for purposes of criminal identification, except a defendant should have access to the results of all database searches and analyses performed in connection with the case. What? So Brian he's entitled to that? That's the use restrictions and destruction of DNA evidence. No. Now we're here for access to DNA databases. Information in a DNA database should be provided only to criminal justice agencies and only for purposes of criminal identification, except a defendant should have access to the results of all database searches and analyses performed in connection with the case. Wait a minute. Does that say right there that Brian's entitled to the information on the 3 unknown DNAs? I don't know. I don't know. That sounds like it says right there. The IGG was not necessarily if they were looking for someone. They tested the DNA, but we're still not sure if it matched to BK or not. We don't know if BK's DNA was actually on the knife sheath. BK should have been named a suspect first. They just did it backwards. I guess the defense is entitled. Okay, thank you for clarifying that, Sheik Beat. Thank you. it matched to someone related to his dad that we know of. I still don't know about how they did that. Because in the protective order, it says a STR profile is likely to be seen if. Now, that's not a real statistic. So they did not use real statistics in their motions. So I'm not sure if it actually matched or not. I know that's what everybody has kind of agreed upon, that it was matched to him, but the way that they worded in the motion, I don't know about that. That's the sus part. You can't take touch DNA, and Ann Taylor is saying, how did you find BK? I'm not sure. Right. Right. Okay. Which one are we on here? The search procedures used to identify profiles relevant to the case, and upon a showing of good cause and any other information related to the database is relevant to the defense. Upon a showing of good cause, a court shall grant a defendant's request to order a comparison of profiles in the database with an unknown profile. Oh, okay. Well, hopefully we get to see that at some point. I'm sure Ann Taylor will request that they see a comparison of those unknown. And I don't know what happens if the prosecution comes back and says, well, we don't have those unknowns anymore. Ugh. Not good. A prosecutor should have access to the same information provided to the defense pursuant to subdivisions A and B of this standard. The agency maintaining a database should be permitted to disclose information about the database for the purpose of seeking advice on quality control and assurance. Persons conducting scientific research on population genetics or related issues may be granted access to genetic profiles in a database for the purposes of that research, provided that the profiles are anonymous, privacy concerns are resolved, and the security to the information is assured, and as allowed by Standard 16-18.2F. Expungement. If any person's conviction is vacated, the person's profile should be expunged from the database that includes the profiles. Okay. And a person has a right to petition the court for that. ABA Criminal Justice Standards on DNA Evidence. Black letter with commentary. Introduction. DNA evidence in criminal justice. When the ABA Criminal Justice Standards were first promulgated in the late 1960s, and even when a second edition was issued in the 1980s, DNA was not a part of the criminal justice landscape. However, that changed dramatically beginning in 1985 with the advent of DNA evidence, and thereafter, as one form after another, DNA technology was introduced at the trial level and was subsequently approved by the appellate court system. The impact of the criminal justice system was also dramatic. As early as 1988, one judge was calling DNA evidence the single greatest advance in the search for truth. Since the advent of cross-examination, less than a decade later, a National Research Council report stated that DNA analysis is one of the greatest technical achievements of criminal investigation since the discovery of fingerprints. Every state has enacted legislation to obtain profiles from convicted offenders for DNA databases, although The targeted offenses and other matters differ widely. The DNA Identification Act of 1994 authorized the FBI to establish the Combined DNA Index System, also known as CODIS, a national database. DNA's discriminatory power combined with computer technology has permitted comparison of DNA profiles derived from samples taken from crime victims and crime scenes with profiles derived from samples taken from subjects stored in local, state, and nationwide databases. The result has been to make DNA evidence an undeniably powerful tool for purposes of convicting the guilty and exonerating the innocent. The capability to find a cold hit in a case without a suspect is particularly important development. It means that DNA evidence can be used not only to construct a case after a suspect has been identified, but also to investigate a case by identifying a previously unknown suspect. The FBI reports that the total number of offender profiles included in the National Database Index System is now more than 3,700,000. And the total number of forensic profiles, those obtained from crime scenes, is more than 150,000, according to the FBI as of October 2006. Well, it's a while ago. CODIS has produced over 38,000 matches or hits that have assisted in more than 40,000 investigations. No less important is the power of DNA evidence to establish the innocence of a suspect or even a convicted offender. The Innocence Project of Cardozo School of Law asserts that since 1989, there have been tens of thousands of cases where prime suspects were arrested or indicted until DNA testing prior to trial proved that they were wrongly accused. The National Institute of Justice issued a report in 1996 that documented 28 cases in which DNA evidence exonerated convicted defendants, and the Innocence Project reports that as of January 2nd, 2007, DNA evidence has resulted in the exoneration of a total of 192 convicted defendants who have served an average of 12 years in prison. The Innocence Project, they have updated stats on that. And I know they're on my Twitter. I don't know if any of you are interested and you know how to use the search feature on Twitter. You can search my profile for different subjects, and the things that I've researched will pop up. Like, for instance, well, on my phone, the search bar is right here, like at the top of my profile. Can you? Yeah, I'm on the right page. And I'm just going to use the find key here because I'm not sure where it is. But if we put in, no, I don't know how to do it. But if you put in like Innocence Project on my profile on Twitter, all the research that I've done on it will populate. Finding that search tool was great for when I need to access, the articles and the things that I've already researched. Okay, let's see what you all are saying. Miss Pottage, welcome. Okay. Where did I leave off, Chic Bait? I think it was on you. Yes, they are entitled. Okay. Chic Baked says, Ann Taylor is setting this up as if BK is a target, like it was all set up, and it's possible because they found no DNA or fingerprints in the database. I don't know about that because they don't have the cell phone data that they say that they have. They don't, it seems like they don't have the evidence to prove where Brian was at a given time. Cassidy Kane says, it seems if the defense cannot replicate the results or do a comp, the DNA should be tossed and anything after would be fruit of the poisonous tree. Right, I think so too, based on the amount of biomaterial, chain of custody, and how do you go from a partial trace profile to a partial like STR to a partial family tree from Ortham. And then the Ortham, I think they did make a SNP, but the FBI didn't compare the SNP from the nice sheet to the defendant's SNP. So I don't know how they got from the SNP to the STRs. The chain of custody will be very interesting to see. I think there's a pretty good chance the DNA will be thrown out. Joanna T. says, one of the court document has writing, court has concern about chain of custody. Saw on some channel weeks ago. Can't remember anymore what channel or specific docket was. I saw that as well. So yeah, it was a handwritten note on a forensic evidence transfer. Mm-hmm. Yeah, Joanna, I think that's interesting that the judge was even concerned about chain of custody. Chain of custody is going to be a big thing here. All right, so where were we? Yeah. Indeed, in cases in which DNA evidence provides compelling evidence of guilt or innocence, legal concepts of finality seem fragile. Recognizing the reliability and durability of such evidence, many jurisdictions have extended their statutes of limitations or permitted John Doe indictments that permit the prosecution involving such evidence to go forward beyond the usual constraints of the law. For some reason, many states and the federal government have enacted statutes providing the post-conviction DNA testing, permitting defendants to challenge their convictions long after the appellate process has concluded. Similarly, in House v. Bell, the United States Supreme Court recently held that the defendant, by using DNA analysis as well as other evidence, had established a compelling claim of actual innocence, thus falling within the exception of the traditional rule that procedural default is a bar to federal habeas corpus review. Problems. Despite the power of DNA evidence, problems have been exposed in its use. For example, the U.S. Department of Justice Inspector General has released 2 reports relating to DNA. One involving misconduct by an FBI analyst in testing, and the other on shortcomings in the CODIS procedures. In addition, the Virginia DNA Laboratory experienced problems originating from the Earl Washington case. The most serious example to date, the Houston Police Department had to close its DNA operations due to major deficiencies, one of which had resulted in a wrongful conviction of Josiah Sutton based on DNA evidence. As described by a subsequent investigation, the DNA section was in shambles, plagued by a leaky roof, operating for years without a line supervisor, overseen by a technical leader who had no personal experience performing DNA analysis and who was lacking the qualifications required under the FBI standards, staffed by underpaid and undertrained analysts, and generating mistake-ridden and poorly documented casework. Errors and misconduct can lead to inaccurate results, which can create injustice in particular cases and discredit DNA evidence as a whole. Consequently, accreditation, proficiency testing, extensive discovery, defense experts, post-conviction testing, and other procedures are vital to ensuring the exoneration of the innocent and conviction of the guilty. Prior consideration of DNA evidence analysis and use. The ABA's DNA standards have benefited from the prior work of a number of organizations which have looked at DNA evidence since the inception, commencing with the Office of Technology Assessment Report in 1990. This was followed by reports by the National Academics in 1992 and 1996. Right, and then it's going to go into like standards. We still have a issue with standards to this day. So what do they have here? Scope and standards. For purposes of these standards, DNA evidence is biological material from which DNA is or can be extracted. These standards are applicable to DNA evidence used for genetic identification in criminal cases. Limits the scope of standards. DNA evidence is found in all living things, including plants, animals, and viruses, the DNA of which all have been subject of criminal litigation. Sources of DNA include blood, semen, hair, bone, saliva, sweat, and dandruff. DNA evidence may be obtained by taking a sample of a source directly from a person or by using it from a place in or thing on which it has been deposited. Extraction of the DNA from the sample is the first step in analyzing DNA evidence. The decision to exclude from coverage of other kinds of biological evidence, such as fingerprints, microscopic hair, and fiber comparisons, was not based on the view that standards were not suitable or necessary in these areas, but rather because extraordinary capability of DNA evidence to inculpate and exonerate, and particularized issues that arise in collecting, gathering, and testing DNA samples made a set of standards devoted exclusively to DNA appropriate. Nonetheless, the principles embodied in standards might as well also be applied to other types of biological evidence, as well as evidence derived from other forensic sciences, such as firearms identification. Well, so this footnote here says, see United States v. Boswell. In a false statement prosecution, DNA used to compare swine blood. State v. Bogan. In a murder case, DNA of seed pods from Palo Verde trees at scene compared to those found in Bogan's trunk. Oh, so they're using DNA in a different way. That's interesting. They use plant DNA there. So State v. Schmidt, in attempted murder by injection of HIV virus, expert testified that HIV from two persons were closely related. See State v. Lally. Canine DNA matched between sample obtained from defendant and murder victim's dog, not generally accepted. Interesting. So they have DNA standards on what kind of DNA is admissible. Cool. General Principles, Standard 16-1.2. Consistent with rights of privacy and due process, DNA evidence should be collected, preserved, tested, and used when it may advance the determination of guilt or innocence. DNA evidence should be collected, preserved, and tested, and the test results interpreted in a manner designed to ensure the highest degree of accuracy and reliability. The policies and procedures employed for DNA testing evidence should be available for public inspection. Test results and their interpretation should be reported and presented in an accurate, fair, complete, and clear manner. A person charged with or convicted of a crime should be provided reasonable access to relevant DNA evidence, and if it has been tested, to test results and their interpretation. The collection of preservation of access to and use of DNA evidence should be regulated to prevent inappropriate intrusion on privacy rights. Funding necessary to achieve these principles should be provided. So, commentary. Standard 1.2 sets forth general principles which are generally directed to assuring the reliability in the testing and interpretation of DNA evidence, providing transparency in the process, from research to trial, protecting privacy to the extent practicable, and affording due process, truth-seeking. As a guiding principle, the criminal justice system should take advantage of the power of DNA evidence to advance the truth-determining function of criminal trials. Other types of evidence, eyewitness identifications, testimony from accomplices, and jailhouse informants, and even some confessions have led to conviction of innocent persons. In cases in which identification is the key issue, DNA evidence, when properly obtained, analyzed, and used, can provide more trustworthy evidence of guilt or innocence. Reliability. To take advantage of DNA's capabilities, biological evidence must be collected, preserved, tested, and interpreted in a manner designed to ensure the highest degree of accuracy and reliability. For the same reason, test results should be reported and presented in an accurate, fair, complete, clear manner. Although courts use terms like validity and reliability interchangeably, the terms have distinct meanings in scientific disciplines. Validity refers to the ability of a test to measure what it is supposed to measure, its accuracy. Reliability refers to whether the same results are obtained in each instance in which the test is performed, its consistency. Validity includes reliability, but the converse is not necessarily true. The Supreme Court acknowledged this distinction in Daubert. We learned about the Daubert method. There's Daubert and Frye, and I believe different states will follow each one in deciding what types of scientific tests to allow information. Okay. Oh, you know what? There was one more thing I wanted to share, but there's something else. Yeah. Tara! Hello and welcome. Very good to see you. So Tara has sent me a DNA article, and I want to bring that one up. That was a very good one. Thank you, Tara. Where did I put it? This is so cool, Tara. That is good. Did you catch my video on that? Sometimes these attorneys' websites have good DNA articles. You found one. Oh, I'm so excited that you found one. Oh, this is really exciting. Okay, so this one is from Jared Craig Law, and on there they have a definition or explanations of secondary DNA transfer and unsafe conviction. This is a key issue here in the Koberger case, and it is directly related to the mainstream media. What has been in the mainstream media is not what's actually going on with the science, with this transfer DNA, this trace DNA. The mainstream media will have you believe that DNA is something other than it really is. For instance, so we don't know how the trace DNA got on the sheath, and we're still not really certain if it is actually Brian's. That is the hypothesis of the state, but yet they didn't really state it properly. And the statistic that they used is a discredited statistic, and I will be interested to learning more about the process in which they came to that conclusion. So, in here, oh, yeah, I totally love it. All right, I just want to check on chat real quick. Secondary DNA transfer and unsafe conviction. The case of Lucas Anderson. This is a very famous case. This opened the door and changed the game for DNA. It'll change it forever. In 2012, Lucas Anderson was charged with murder. The case against Anderson was circumstantial, based solely on evidence of DNA transference, but it was later learned that his DNA had made it to the crime scene by way of the paramedics who had treated Anderson earlier on the same day and later arrived at the victim's residence, inadvertently transferring DNA evidence to the crime scene 3 hours later. Anderson's case has been described as definitive example of how, absent appropriate skepticism and restraint, the criminal justice system's reliance on DNA as infallible carries significant risks and may lead to miscarriages of justice. That is very well written. Let me read that one again. Anderson's case has been described as the definitive example of how, absent appropriate skepticism and restraint, the criminal justice system's reliance on DNA evidence as infallible carries significant risks and may lead to miscarriages of justice. So true. Yeah. So Anderson was that. See, example of definitive example of how we should be skeptical of the DNA evidence because of that. So, DNA evidence generally as the carrier of each person's genetic code. DNA profiles can be used as circumstantial evidence of identity. Since first being accepted in Canada, countless crimes which could have otherwise remained unsolved have had suspects identified by DNA. Just as importantly, hundreds of wrongful convictions have been exposed as a result of DNA testing. As Justice Cairns observed 25 years ago, assuming appropriate scientific care in gathering and testing DNA evidence is the most dramatic forensic evidence ever discovered. Courts have also been aware of the risks of DNA evidence that a trier of fact may be tempted to equate fantastic odds, couched in terms as quintillion, with the likelihood that the accused was guilty. This is taken with concerns such as potential for contamination, laboratory error, and inadvertent transfer. In this respect, DNA analysis is too often viewed as a crisp, objective, near infallible science, or as a crystal ball being handed to the criminal justice system. I like this attorney whoever wrote this. They're funny. But history teaches us about dangers of unreliable forensic expert evidence and this connection to wrongful conviction. Those alive to history's lessons should see recent developments in forensic DNA analysis as a call for heightened vigilance. Secondary DNA transfer. There are 3 modes of DNA transfer, all based on Locard's exchange principle. Primary DNA transfer is the passage of DNA to objects and people. Where a perpetrator handles a knife, they may deposit DNA by way of primary transfer. Secondary transfer occurs when DNA is transferred between an object or a person through an intermediary. For example, if two individuals shake hands, then one person handles a knife. DNA from the first person may transfer to the second during a handshake, and then it is deposited on the knife when the second person touches it. Similarly, if one individual, then another, handles a knife, the DNA from the first person may be picked up by the second person. Tertiary transfer occurs when there is indirect transfer through two intermediaries. For example, one person touches a doorknob, and then the second person touches a doorknob. The second person then handles a knife. DNA that can then be transferred from the first person to the doorknob to the second person who deposits the first person's DNA on the knife. Identifying the correct question. Whose DNA is it, and how it got there, and when? The literature has now identified the need to distinguish between two very different questions. Over the last several years, an increasing number of cases no longer question whose DNA is it, but wish to know how or when it got there. Wow. That question has shifted our entire judicial system. And that question comes with responsibility as a juror. It's no longer your DNA was found at a crime scene, so you probably did it. The question now is, because of the advancements in science, no longer like CSI, how and when did it get there? That's definitely the appropriate question. And then once you figure out the how or the when, or you can't figure out the how or the when, then you might not be looking at the person who did it, even though their DNA was possibly there. Very good, Tara. I love this article. Okay. Scientists in forensic DNA analysis have identified an increasing need to understand how the DNA within a trace got to where it was collected from. The first branch of inquiry, whose DNA is it, relates to DNA comparison and statistical analysis. It enjoys reliable techniques for testing and an established base of literature. It is reflected in a plethora of investigations of primary transfer and under what conditions primary transfer DNA occurs. The second branch, how it got there, is very different. In 2009, an article in the International Journal of Forensic Science, A.H. Rowland and his colleagues identified this as a novel field. Okay. So A.H. Rowland and his colleagues identified this as a novel field of inquiry falling under the umbrella of DNA transfer, persistence, prevalence, and recovery. DNA TPPR, I have seen that in the DNA TPPR in some of the scholarly journals I read. So they use that, and they still talk about that particular function of DNA. Unlike DNA comparison, there is no consensus as to the nature and occurrence of secondary and tertiary modes of transfer. If there is any consensus, it is the present state of the science poses dangers to forensic DNA evidence being introduced in court. The paucity of research and empirical data. DNA profiling allows results to be generated from small traces of DNA. Small amounts may not correlate with activity level, and DNA from an innocent person may be brought to the scene via secondary transfer. As Gorey and Van Oorschot explained, Van Oorschot is one of the first writers of DNA. Anyway, his name is in a lot of things, and his name is also a lot in the source or reference section at the end of a lot of these scholarly journals that I read. So he's a big deal. Well, both of them, because they both wrote it, but Oorschot in particular. Okay, so Gorey and Van Oorschot explained scenarios incorporating multiple DNA transfer steps rather than direct transfer are increasingly being raised in courts as potential means for the presence of the defendant's DNA at crime scene or a piece of evidence. However, little is published about DNA transfer in uncontrolled or real-life situations, and advancements in this area have not kept pace with other developments. Taylor and his colleagues note, absent further advancements by just the properties of the DNA profile obtained, no definitive conclusions can be made by an analyst as to whether it had resulted in primary or secondary transfer. That's a fact. And that relates to the question that is going to change the judicial system and should be asked by responsible jurors. How and when, not who. Cal notes there is a paucity of research projects regarding the continued or secondary transfer of DNA. Rowland notes of empirical data and variables that may or may not impact DNA TPPR. Previous wrongful convictions have led to calls for caution in respect to assessments based on fundamental misapprehensions of the nature of secondary transfer DNA. Right. The very nature of secondary transfer is movement. And a lot of times it's not associated with the crime that had occurred. In 2016, study by Kale and her colleagues, subjects were asked to shake hands for 2 minutes, and then each handles a knife. In 85% of cases, the DNA of the other person was transferred to the knife. In 1/5 of the samples, the DNA analysis identified this other person as the main and only contributor of the DNA to the weapon. In other words, in 20% of the cases, secondary transfer resulted not only in a primary profile, but there was no DNA profile for the original individual. In 2017, Gorey and Van Oorschot of the Victoria Police Forensic Services Centre in Australia. Oh, is Oorschot Australia? Cool. Maybe. Conducted a lab experiment designed to mimic everyday interactions. Volunteers sat at a table and shared a jug of juice. After 20 minutes, subjects' hands, the chairs, the table, the jug, the glasses were swabbed and tested. Then, although volunteers never touched each other, 50% had another person's DNA on their hand. 1/3 of the glasses bore the DNA of volunteers who had not touched them. Further, there were several samples of the transferred DNA was a major component. The authors concluded that this study shows how communally used objects serve as reservoirs of material available for DNA transfer. Right. In another peer review studies, it was found that 50% of subjects tested had the DNA of another individual on their neck. That 13 to 15% of people have traces of someone else's DNA under their fingernails. That an area can be contaminated with the DNA of a stationary person speaking in as little as 30 seconds. And there are many more examples in this literature. However, a cursory review of the literature shows that leading researchers continue to caution against the dangers inherent in the expert evidence as to DNA TPPR and expert evidence about the how and when of the DNA transfer. There is a broad acknowledgement that a perpetrator of a crime could bring traces of another individual into a crime scene and deposit these traces via secondary transfer. This could falsely link someone to the scene of the crime and could lead analysts and other medicological professionals to falsely conclude that DNA left on an object is a result of direct contact, especially for a removable object such as a knife sheath. Movable object. Judicial response to risks of secondary transfer. Trial judge as gatekeeper. The judge is a gatekeeper for sure. Alongside a growing awareness of the risks of secondary transfer, the reaction of Canadian courts has been varied. That said, in a number of promising decisions, courts have shown an acute awareness of these risks. For on one front, courts have continually acknowledged the need for rigid adherence to principles governing expert evidence. Expert evidence is both immensely important to legal adjudication and equally dangerous. The concern is where an expert witness, veiled in their authority, and bolstered by often superior knowledge, provides evidence cloaked under the mystique of science. It may be perceived as being virtually infallible and having more weight than it deserves. History teaches us of the dangers of expert evidence. In the worst of cases, dubious expert evidence has contributed to wrongful convictions. There is documented evidence of that. There's studies of that. And there's a number of studies that do that they were able to learn a little bit from that. And standards are changing, but standards are not across the board. Anyway, as such, procedural and evidentiary safeguards govern expert evidence, reflecting the trial judge's obligation as gatekeeper to safeguard the trial against prejudicial expert evidence and to exclude it when it is not demonstratively reliable. Expert evidence related to the question of whose DNA is it falls squarely under the ambit of standard forensic DNA analysis. However, the issue of how it got there and when is very different And in circumstantial cases involving DNA evidence, it is often the ultimate issue. For this reason, in recent decisions, courts have been cautious about scrutinizing the permissible scope of expert evidence related to secondary DNA transfer and are beginning to appreciate the significance of this distinction. For example, in R.V. Sabry, a swab taken from the complainant's breast contained the accused's DNA profile. DNA evidence was central to the case. The trial judge found that the Crown had not advanced sufficient evidence to rebut the possibility of secondary transfer. While the expert had concluded that some transference scenarios were more likely than others, her conclusion seemed to be grounded in common sense rather than a result of scientific studies or testing. Absent more information about the scientific foundation of her conclusions, I find myself without any real ability to assess them and am cautious about placing any weight upon them. I am also mindful that Mrs. Shaker was qualified as an expert in comparison and analysis of DNA. She was not qualified as an expert in transference of DNA. It is critical that an expert to be confined to giving evidence only in those areas that they have properly qualified. I find that Ms. Shaker's evidence about transference outside of her expertise, and as such impacts the amount of weight I am prepared to place upon it. That was beautiful. Whatever judge said that. In acquitting the accused, the trial judge concluded that while she accepted that DNA was found on the complainant's left breast, while I am not sure of how it got there, in R.V. Hall, the accused appealed on the basis that the trial judge erred in his charge to the jury related to the secondary transfer. The MBCA found that the charge was sufficient. However, this was based on the absence of expert evidence as to the likelihood of the manner of DNA transfer. Likelihood of the manner. All right. What is the relevance? What is relevant is that MBCA noted the admissibility of such evidence is an open question, at least in Canada, citing the SCC decision in Hour. Was an appeal from a decision of the ABCA stemming from a conviction of a sexual assault at trial. There were competing experts and central issue related to the rate, occurrence, and possibility of secondary transfer. The ABCA upheld the decision of the trial judge. In dissenting reasons, Justice Berger found that one cannot reliably infer the origin or mode of transfer simply from the amount of DNA found, and that no ready-made inference was available to be drawn from the presence of the DNA to the potential mode of transfer. The SCC overturned the decision and ordered a new trial on the basis that the trial judge did not assess the competing expert evidence in a balanced manner. Justice Moldaver observed that the SCC need not finally decide the issue of whether the impunged evidence of the Crown's DNA expert as to the source of the complainant's DNA was or was not admissible. In Canada, the full import of such decisions and standards governing the admissions of expert evidence related to DNA, TPPR, and secondary DNA transfer remains to be seen. That said, a greater understanding of the phenomenon of secondary and tertiary transfer call for a greater vigilance as Loca Bucci cautions. To function well, the system requires that judges, lawyers, and expert witnesses all do their part. Rigid adherence to principles governing circumstantial evidence. In addition to ensuring trial judges strictly adhere to gatekeeping function, in recent years, Canadian courts have been very careful in scrutinizing the reliability of DNA evidence in circumstantial cases. It has been found that DNA evidence, powerful evidence that the person whose DNA is on the object was in contact with the object. However, the connection of the accused with the crime will depend on the existence of other evidence capable of establishing contact with the object at the relevant time and place. In R.B. Grayson, the accused was charged with the theft of a vehicle, which was found abandoned 2 days later. The accused's DNA was found on the baklava located in the vehicle. The ONCA overturned his conviction and entered an acquittal, having applied the two-stage test set out in DDT. The court observed that the Crown cannot point to any evidence that makes the inference that the appellant was in contact with the garment in connection with the theft more likely than the inference that he was in contact with the baklava at some other time. Evidence of the accused's DNA on the baklava only demonstrates that he likely wore the garment at some point in time. In R.V. McGinn, the accused was charged with offenses stemming from an armed robbery of a liquor store. The case was based on DNA located on a neck warmer located in a stolen car later that night. In reaching his decision, Justice Lee considered expert evidence related to the possibility of DNA transfer between persons and the possibility that an individual could wear an item and leave no DNA at all. Justice Lee found that this clearly establishes the limitations of that evidence. He found that the DNA evidence is only at some point in time the accused's DNA came in contact with the black neck warmer. This was inefficient to establish identity. In R.V. Galineski and Johnson, 2 men were charged with breaking and entering. Evidence against the co-accused was circumstantial based on evidence from items recovered from the complaint's property. One accused called a witness offering an innocent explanation for the DNA, while the other called no evidence, and the court considered expert evidence related to secondary transfer. It found that DNA evidence established at best the accused persons had handled the relevant items, but so did at least another individual. Both accused were acquitted. The connections are just too tenuous and the possibilities are too varied. R.V. Hodgson involved an attack on a female. The complainant had broken free of her attacker, who dropped a glove during the struggle and fled. As confirmed by video footage, the court considered evidence of clothing seized by the accused residents, argued to match that description in the video. The Crown's case, otherwise entirely based on DNA evidence from the glove that matched the accused, or, as the trial judge described it, the possibility that the DNA in the sample came from somebody other than Mr. Hodgson is so statistically unlikely as to be insufficient. The trial judge noted the evidence of a Crown expert, Miss Popovic, that while the accused was a major contributor, there were also two minor contributors whose samples were not suitable for comparison. The court states as follows: Ms. Popovic testified that she was unable to say whether the major contributor was the last person to have worn the glove, nor was she able to say when any of the samples were deposited. She gave no evidence as to what inferences, if any, could be drawn from the fact that there was a larger amount of DNA from the major contributor than the minor contributors. The court identified the importance of DNA evidence and the need to identify the limits of what is capable of proving. Significantly, the court distinguished previous decisions in which DNA evidence was sufficient to establish guilt because in those cases only a single DNA profile was found on the items in question. The court rejected arguments by the Crown that there was no evidence that the unknown individuals wore the glove, matched the description, or owned similar clothing, and found that to accede to such arguments would be to fall into the error identified in the Valla Roman, requiring alternate inferences to be based on proven facts. Even the Crown is correct that it is objectively improbable that one of the other two individuals wore the glove, fit the description, and owned similar clothing. This establishes only that Mr. Hodgson was probably the perpetrator. Probable guilt cannot ground a conviction. In my view, the use of the language of the Valla Roman, it is a plausible theory or reasonable possibility. One that of the other two unknown individuals who wore the glove matched the genetic description and owned a black hoodie and beige shorts. In the result, the Crown had not proven identity beyond a reasonable doubt. In R.V. Donahue, an accused was convicted of breaking and entering. It was admitted that the accused DNA was found in a glove, on a purse, and on the kitchen counter. In a terse judgment delivered Curran from the bench on the ONCA overturned the conviction and entered an acquittal. It found the Crown had called no expert evidence on the characteristics of DNA evidence or how it may be transferred. Whether the appellant's DNA was the sole profile on the glove, it states the evidence established that the appellant was connected to the glove. The evidence further established that the glove was clearly connected to the commission of the crime. However, standing alone, the DNA evidence had led at trial was incapable of bearing the burden of proving that the appellant left the glove at the scene of the break and enter. The evidence established that the appellant was connected to the glove. Okay. The evidence further established that the glove was clearly connected to the commission of the crime. Okay. However, standing alone, the DNA evidence at trial was incapable of bearing the burden of proving that the appellant left the glove at the scene. Yeah, how do you prove that? The decision confirms that presence of the accused DNA is not determinative of guilt and does not lead inexorably to only one inference as to support a conviction at trial. The import of these decisions is that there is a growing judicial awareness of the dangers of unethical reliance on DNA evidence, particularly in the filings and the gaps in the evidence occasioned by the absence of credible expert evidence as to how and when of DNA transfer. The law is settled, and reasonable possibilities that can be inferred from circumstantial evidence cannot based on speculation, but must be based on common sense and human experience. However, particularly in these cases involving DNA transfer, our intuitions about what is possible or probable do not always accord with established science. While intuitively possible inference based on seemingly high unlikely, they are not improbable. They may, in the universe of what is possible, seem less unlikely than DNA transferring miles to a crime scene by paramedics, as in the case of Louis Anderson. That's right. This concept of transference is something that is beyond usually what the average person would consider likely, because that's not like what we hold of what DNA means to us. I keep using the CSI effect. The CSI effect didn't go into transfer DNA, and so it's going to be hard for people to visualize. Yeah, the transfers of DNA is a science all in itself, especially when it comes to this transferred DNA. And our current account for it as a public, that it's just not there. And I guess it does seem unlikely at this point, but I think as time goes on, the public will adopt that, and it will become something that we consider to be common sense. It's just not there yet, I guess. Concluding remarks. A growing awareness of the phenomenon of secondary and tertiary transferred DNA highlights the importance of the presumption of innocence and why safeguards are required to protect against the dangers of unreliable expert evidence, invalid science offered by a seemingly impressive expert may distract from defective methodology. A review of the literature demonstrates a lack of consensus on secondary transfer. The consensus is there and is a growing recognition of this phenomenon can and has led to individuals being falsely linked to crimes. In closing, the writer would call for all stakeholders in the criminal justice system remain vigilant and exercise an appropriate degree of skepticism and restraint in light of recent scientific advancements in this field. This is necessary to ensure concerns about secondary DNA transfer and unsafe convictions are meaningfully addressed as a part of our shared interest in the pursuit of justice. Wow. That was an amazing article. Wow. That article was secondary transfer and unsafe conviction. Right. I think the more and more science we have, it is showing that the transference of DNA is a DNA field all in itself. Okay. Oh, thank you, Joanna. That's so sweet. Okay. I didn't want to interrupt reading because I think sometimes like when I finish through and then come back, but I don't know where. I'm trying to scroll up here to see where I left off so I can read up some of your comments. Oh, here we go. Okay. So, Joanna T. You're definitely not crazy. The case is crazy, for sure. Yeah. Cassidy Kane says, I think there's definitely a groundswell of people that see this as a big problem. I think you're right. Yeah. Sheikbait. Kane. Oh, BK can't get a fair trial in Utah County. I would agree. Cassidy Kane says, I'd like to know when the profile was complete from the knife sheath too. Yeah. Sheikbait brings up an excellent point. They found a sheath but never said what weapon did all this. Very true. Cassidy Kane says, what was being placed or taken from that dumpster? If I was AT funding who those guys were would be a high priority. Yeah. Yeah, I hope that comes up at trial as well, Sheikbait. Sheikbait also says almost no clues point to BK. I would agree. You bring up an interesting point, Cassidy King, because BK probably said since the beginning, yeah, I was out driving. Like, look at my cell phone. I wasn't anywhere near there. So then, like, Moscow PD took it upon themselves, like, well, he was out. Let's make it fit. The case hinges on AT asking, how did you find my client? Right? Well, she's establishing that. And yeah, she created that, didn't she? Yeah, good point. Tara says, yeah, everyone knows about this case. It's highly used, but the article gets better further on. Oh, you're not kidding. That article was just, that should have been a closing argument. It was so good. Right. This DNA does closely look at specifically transferred DNA. I think they've got a point. Transference DNA, that needs to be a whole field of study in forensics. It's well written and easy to understand. Yeah, major points for that. Joanna T says, many similar cases. Lucas Anderson had an alibi. Well, so has Brian, but time is crucial in this case. Other case example are Mark Carver, Amanda Knox. Officers, EMT, and investigators transferred those. Yep. Sarah D. Irish says, we should try to rewatch Mercer and Bicker's hearings again. Oh my god, that is such a good idea. I always learn something new from them regarding DNA. Yep. That's a great idea, Sarah. Yeah. Yeah. Regarding that part where 20%, that is a lot. Tara! Australia is leading in DNA studies. I don't doubt it. Australia is awesome. Tara says, so, say Brian had a conversation with someone who went on to touch the sheet, right? You just have to be 30 seconds of speaking. within it. I don't know the amount of space, and that his DNA could be on anybody walking by or anybody who will walk by and touch something and walk away. Right. Joanna T says, no need to touch at all, but of course, same place directed or secondary trace need to be. Yeah. Tara says, what we want to learn in case studies that have come back not guilty. Joanna T says, say, like, officer touched doorknob, then investigator touched it too with gloves, and the shoe took to evidence. Scary. Yeah. Yeah. Because no matter who is wearing gloves, right, their hands are protected in gloves, but DNA can live and exist on the outside of somebody who's already wearing gloves. And since everybody grabs things with their hands, even if you're wearing gloves and your DNA isn't on your own gloves, you could have somebody else's DNA on the outside of your gloves, and you're going around grabbing and touching things like we normally do, and you're unknowingly transferring DNA to different locations or right onto evidence. And so, yeah, the glove thing. We watched that video of some Sydney Yonker. I forget her name, but she was doing her master's, I guess, thesis on secondary transfer DNA and gloves. Particularly, she was trying to show a demonstration. And she went as far as she was going to play the role as like the investigator. I have a video about it on my YouTube page. But yeah, I guess she had a whole team of people to create that. So I wonder if it was like a play / hey, look at the PowerPoint of like the paperwork that we would do. And that would also serve as like the storytelling for her thesis. But it also demonstrates the academic need to understand the transference of secondary DNA and how a glove can be used to describe what it is, like just as a demonstrative tool. Tara says, yes, that was a case with Mark Carver. He shook the officer. Joanna T says, Carver was acquitted because they found out officer shake his hand and then went to the victim's car. Yeah. So how did he open the car door? He used his hand. So, I mean, how many people's DNA do we have on our own hands at one time? It's going to be really important that Anne gets the transfer DNA expert if the DNA goes to trial. Yep. Yep. Okay. Joanna T says, to Tara, have you found any connections to Koberger about officers in King Road? I have one. K9 Officer Sydney. How about Professor Snyder at WSU? Brian's boss. Okay. Brian's professor was related to an MPD officer? Really? Oh, yes, that was found sometime. Interesting. That could easily be how Brian's DNA transferred into anything. Wait a minute. Tara, one of the frat guys was a TA? Oh, but he was a TA at the University of Idaho. Okay. Yeah, Tara, it's so important that Anne has somebody talk about transference, DNA transference. Oh, thank you, Joanna T. Yeah, I love DNA. Tara says 20th of November when Idaho got the STR DNA profile. And then Ortham was enforced on the 29th. Oh, thank you for confirming that, Tara. You'll be up for rewatching. Cool. Cassidy Kane says the field of study BK was in puts him in proximity to the officer's equipment, and not to mention he has applied for work. Yep, 100% Cassidy Kane. He has also a fairly recent contact with officers. Yeah, definitely. I have always been fascinated with DNA. Even in college, it's really one of the things I would always read about. And college for me was a part of my life where I learned the most about everything. So, I learned more outside of school than I did in. So I don't know if that's like a time in our lives where we're just open and we absorb all of the information around us. But, you know, I was learning a lot about health and biology and managing, like hospitals and health systems and like how the health system is piecemealed together and like all of this stuff. And then, DNA was always a highlight anytime that was brought up in class or any like assignment that we were assigned where we had to do some research. So I'd always pick something like DNA or health tech related. Yeah, DNA. I can't believe it. And you know what else I learned? Because I've been thinking about how the prosecution has stated an STR profile is likely to be seen. I found a connection. I don't know if it's related at all, but it could explain why something is worded that way. I found something called this is it. This is related to genetic genealogy. So I'm caught up in chat, so I don't know where all of you went, but I found this. Like, I really wish that StreamYard would let me sit here and look at chat and scroll on the page I'm sharing. Cassidy Kane says, the older I get, the more and more I want to learn about. Yeah. You realize more how interesting everything is. Definitely. I agree. I learned something about, let me put the find function on here. It was called predictive. Okay, so this talks about why STR DNA testing kits for family tree DNA. So right here, it's saying that the things that they use for these STR kits, the family tree DNA, You can purchase both Y37 and Y111R short tandem repeat Y DNA tests that provide matching the number of locations you purchase, plus a predicted haplogroup based on those results. These haplo predictions are accurate, but are often relatively far back in time. Now, if you don't know what a haplogroup is, we'll go over that. The haplogroup, from what I've been reading, is closer to SNP, but apparently you can find a haplogroup within the STR test as well. So when viewing matches on the big Y700 test, what about that? I think it's funny they call it the big Y. Haplogroup matching is more specific and reliable than STR matches because the mutations, SNPs, single nucleotide polymorphisms that form haplogroups, are much more stable than STRs, which mutate unpredictably. So, quickly before I go on to the next thing, SNP confirmation tests. Historically, family tree DNA customers could purchase individual SNPs to confirm a haplogroup, or SMP packs or bundles do the same for a group of SNPs. With the advent of both Family Finder haplogroup assignments and the big Y700 test, these individual tests are no longer necessary or advantageous and are being discontinued. But here's the big Y. The big Y700 test provides the most granular and specific haplogroup possible, most often well within the genealogical time frame. You may be able to tell, based on previous undiscovered mutations, that two people are brothers or father and son, or depending on who else has tested and when mutations form. Testers may match further back in time. Here's an example of using the results from the multiple testers in the Estes DNA Surname Project. You can also match to men who took the big Y500 tests, which is less specific than the big Y700. All right, so just note what the BY700 is, and then I'm going to come back to that. Oh, is it going to make me pay for it, or is it going to tell me? Oh. So they do have a Y-DNA data matching database. Connect with men who share your Y-DNA and trace your father's line back to a single common ancestor. Okay? So it's a DNA test just for the Y chromosome. Okay, thanks, Tara. I'm glad you're watching, listening. Yeah, there's a few of you that still hung on. All right. Now, this says here, what do you mean by match? Matching doesn't mean you have the exact haplogroup. A perfectly valid match can be a different haplogroup because one haplogroup is more specific or refined than another, matching exactly as a result of a predicted STR haplogroup. That was the phrase. All right. Is much less useful than matching closely on much more recent big Y700 haplogroup. Not all haplogroups are created equal. I know this is a bit confusing, so let's look at a real life example to clarify. Oh, they're going to give us an example. Okay, so STR to STR or autosomal to autosomal haplogroup match. Two males might match exactly on the mid-range family finder, autosomal haplogroup, or a STR predicted haplogroup like RM269, which is about 6,350 years old. All right, so haplogroup is from a period in time. This one is the R haplogroup, and it's from the 4350 BCE. And men who are in this haplogroup share a common ancestor from this time period. Descendants of the RM269 are from these countries: Ireland, United States, England, and some others. Wow. Okay, this haplogroup match, even though it might be exact, does not confirm a close match and really only serves to eliminate some other haplogroups and confirm that a closer match is possible. For example, the RM269 men don't match someone in a haplogroup J. I'll show you the haplogroups in just a minute. Or E, you may not share a surname. You may or may not still match if you both upgrade to the big Y. All right, so before I get further into this, I just wanted, so with this, just let it pile on, let it be, you don't have to understand everything right away. Okay, so this family finder tool, family finder haplogroups, always replace STR predicted haplogroups, since they are always more specific than the predicted STR haplogroup. Big Y 700 haplogroups always replace STR generated haplogroup predictions. Because they are most specific. Let's compare these results using Discover. So Jose's son's original predicted haplogroup was RM269. So I guess this is where the common ancestor is, from 4350 BC. Okay, so it looks like they traced in the same haplogroup R to another male ancestor from 1900 BC, and then from okay, so this is going to go through a whole thing. Maybe I got to start up here at the beginning. So using Discover to compare haplogroups. You can use the Discover tool to compare two haplogroups. Okay? See how your Y-DNA haplogroup compares to that of a friend or family member. Enter another haplogroup to see how it connects with yours. Add the second haplogroup. So they're selecting M30. E is another haplogroup and a completely different branch of the polygenic tree. So the RM269 haplogroup was formed about 6,350 years ago, while E M35 was formed about 25,000 years ago. Their common ancestor was formed about 65,000 years ago. Clearly, these two parental lineages are not related in anything close to a genealogical time frame. These two men would never match to an STR test, but could easily match on an autosomal test on any line other than their direct parental line. I don't know how they do that. Now let's compare two haplogroups that are more closely related. Okay, so we're going to compare haplogroup RM269. Okay, so before we get into that, I can show you your haplogroup map. Yeah, gotta read through it several times, Tara. Me too. So your DNA haplogroup attempts to describe the deep history and migration paths of some of your ancestors. Your Y-DNA haplogroup pertains to the origins of your direct parental line. Your mtDNA haplogroup points to your direct maternal line. So you have Y-DNA and mtDNA. So Y-DNA would be the dad side, mtDNA is the mom, the maternal line. Okay. So haplogroups point to deep ancestral places thousands of years ago, not hundreds of years ago. Most DNA test results that come with the haplogroup results just show how high-level haplogroups. These probably aren't going to help you identify the national origins of 3x three-time great grandparent, such as whether she was Irish or Italian or whether he hailed from Monaco or Egypt, and they don't solely point to one place because ancient populations like today's were on the move. Okay, so your mtDNA haplogroup. Both men and women have mtDNA haplogroup. Since mothers pass it to their children, only women continue to pass it to the next generation, which is why mtDNA is associated strictly with your maternal line. An mtDNA haplogroup assignment is a combination of letters and numbers. Both Living DNA and 23andMe provide some basic MTA haplogroup information with their autosomal DNA tests. These may include just a few characters of your full haplogroup. It's like receiving high-level assignment to a very big and old haplogroup branch. Only taking an MTA DNA test family tree will give you the detailed or refined haplogroup information. A good way to think of those different levels is like telling someone that your shirt is green versus telling them it is chartreuse. Both are true, but the latter is more specific. Here's a haplogroup map of the locations and migratory paths scientists believe are associated with various mtDNA haplogroups. So, the haplogroups in Australia are they SPQOMNR? And I see a red line. And red looks like that haplogroup could go back to 55 to 30,000 years. Yeah. So, okay. Your Y DNA haplogroup. Y DNA testing can only be done by genetic males. So, if you're a woman, ask about direct male descendant on the line you're exploring to take a Y DNA test. Okay, so Y DNA haplogroup map below shows the general deep ancestral places and migratory paths associated with various haplogroups shown at the highest levels. This is a lot to take in. Yeah. Oh, this wasn't the. Oh. Okay. I had a um oh, this one's really good, I think. So haplogroups have numbers and letters. Here is some very basic information about each group. Haplogroup R1b is the most frequently occurring perennial lineage in Western Europe, as well as some parts of Russia. And then they have haplogroup 1RA. It is distributed in a large region of Eurasia. Haplogroup N. It has a wide geographic distribution throughout northern Eurasia. Haplogroup I1, Sweden and western Finland. I2, the Dinaric Alps and the Balkans. Haplogroup J is the Middle East. J2, Western Asia, Central Asia, South Asia, and North Africa. Haplogroup E. Most members of haplogroup EM96 are found almost exclusively in Africa. Haplogroup G. At the level of national populations, GM201 is the most common, found in Georgia. So, if we go up here, haplogroup R1b is here. And I also think that's England as well. R1a right here, Russia. Haplogroup N up here. Was that Finland? Eurasia. I1. What is that? Sweden. I2 down here. Okay. So I think Brian is probably R1b. Okay. Okay, so R1a is estimated to have occurred 25,000 years ago. Perennial lineages R1b and R1a. Oh, so following are SNPs that are associated with R1A1A. That's cool. Okay, so we know. Oh, I didn't get to show you what I'm looking at, did I? Okay. So this is all about haplogroup R1A. But that's not. Well, okay. Uh-oh. So the origins of this is 25,000 years ago. Okay, so it's saying haplogroup R1A or haplogroup RM420 is a human Y chromosome haplogroup. And that's what we were looking at earlier. So in human genetics, a human Y chromosome DNA haplogroup is a haplogroup defined by specific mutations in the non-recombining portions of the DNA on the male-specific Y chromosome, Y-DNA. Individuals with a haplogroup or similar numbers in STRs and SNPs. So Y-DNA haplogroups are defined by the presence of a series of Y-DNA SNPs. Okay. So Brian is probably haplogroup R. Here, it's haplogroup R, right? No. Did I get that wrong? Yeah, that's right. Yeah, because haplogroup R1b is the dominant haplogroup for Western Europe. Oh, now we have the haplogroup name in this column, the possible time, and the place. Most recent common ancestor. Yeah. Yeah. So it sounds like MPD did the Y DNA thing, and they said I don't know, the IgG stuff doesn't make any sense, but if they did, they would have come up with a SNP, and this haplogroup R would be associated with the SNP. So, and the R we know is from England, Ireland, and parts of the United States. It's from the migration patterns. Yeah, the alleles. Cassidy Kane, I'm interested to know about the alleles as well. Joanna T says, Kohlberger mom has Italian heritage and the father has German heritage. So I read somewhere. I read that too. All right, so now that we know haplogroups, so what they would do is they take, well, whatever haplogroup Brian is, they would have identified it. And to figure out if this male was related to this male, they would compare them. And one of these haplogroups is older than the other. So haplogroup RM22 was one of the males and is a descendant of the haplogroup RM269, which we can kind of see because they're both from haplogroup R, and they have different identifiers here, the M269 and the M222. Okay. And so then they went further down, and they said the older haplogroup, their ancestral path, they go through all that, and they determine that there are 17 steps between the criteria that they use, between the one male's haplogroup and the other male's from the Y DNA they did. This big Y7. So after you figure that out, the big Y700 to autosomal or STR haplogroup comparison. So Joe, he took the big Y700 STR thing and discovered he was haplogroup R with this identifier here. So Joe noticed that his son, who had initially taken the STR test, had been assigned haplogroup RM269. Then his son took Family Finder test and his haplogroup changed to RFGC, and Joe was confused why his son's haplogroup didn't match. So first, let's check the Family Finder to confirm the parent-child relationship. Joe's son is clearly his son. It is? So why doesn't Joe's son's haplogroup match Joe's haplogroup? And why did Joe's son's haplogroup change? Joe's son had not taken the big Y700 DNA test, so Joe's son's M269 haplogroup was initially predicted from his STR test. So they're just predicting stuff. I'm trying to answer a question here of why they would use this phrase. Predicted STR haplogroups. Joe's son's updated haplogroup was RFGC and was generated by the Family Finder test. Think of this as a bonus. If you're a male and haven't yet, you'll soon receive an email telling you you've reached the Family Finder Y DNA haplogroup. It's your lucky day. Family Finder haplogroups always replace STR predicted haplogroups since they're always more specific than predicted STR haplogroup. Oh, I don't know. I'm tired. I think I've been on here for a while. Yeah, I don't think I'll go for too much longer. I will wrap this up somehow. yeah, I did have one more thing to show you. Yeah, we'll wrap up with that. Where did I put it? Here it is. Okay. So this is from Sarah D. Irish. This says grounds for challenging lack of probable cause in Idaho State. In Idaho, an attorney can challenge the lack of probable cause on various grounds to defend their client against criminal charges. Probable cause is a legal standard that requires a reasonable belief that a crime has been committed before making an arrest or conducting a search. Challenging the lack of probable cause is crucial in protecting individuals from unjust prosecution, ensuring that law enforcement follows proper procedures. 1. Insufficient evidence. One common ground for challenging the lack of probable cause is arguing that there was insufficient evidence to support the arrest or search. If the evidence presented by law enforcement does not meet the standard of probable cause, an attorney can argue that the arrest or search was unjustified. 2. Violation of Fourth Amendment rights. Another basis for challenging probable cause is alleging a violation of the Fourth Amendment rights against unreasonable search and seizures. If law enforcement conducted a search or seizure without a warrant, meeting the requirements for warrantless searches, an attorney can challenge the lack of probable cause based on the constitutional violations. 3. False information or misrepresentations. Attorneys can also challenge probable cause by demonstrating that law enforcement officers provided false information or intentionally misrepresented facts to obtain a warrant to justify an arrest. If it can be proven that the information used to establish probable cause was inaccurate or misleading, it undermines the validity of the arrest or search. 4. Improper conduct by law enforcement. Challenging probable cause may also involve alleging improper conduct by law enforcement officers during investigations such as coercion, entrapment, and other forms of misconduct. If law enforcement acted improperly in obtaining evidence or making an arrest, it can be grounds for challenging the lack of probable cause. 5. Unreliable informants. If probable cause was based on information provided by informants, attorneys can challenge its validity and by questioning the reliability and credibility of sources. Unverified tips from informants may not meet the standard required for establishing probable cause. Specifically, if there are doubts about their trustworthiness. I get tired. So, can unverified tips also be confirmed from FBI? Number 6, procedural errors. Attorneys can challenge the lack of probable cause based on procedural errors committed by law enforcement during investigation or arrest. The arrest process. Failure to follow proper procedures, such as not reading Miranda rights or conducting an illegal search, can be grounds for challenging probable cause. In summary, attorneys in Idaho can challenge lack of probable cause on various grounds, including insufficient evidence, Fourth Amendment violations, false information, improper conduct by law enforcement, unreliable informants, and procedural errors by effectively challenging probable cause. Defense attorneys aim to protect their clients' rights to ensure fair treatment under the law. Now, like Nassau said, motions to suppress are coming, but not only that, there are possibly Frank's motions coming. And Frank's motions will establish some of this, and they're going to challenge that probable cause. And I'd be very interested to know the information that they have to be able to do that. And they must have information to be able to do that, or else Eliza Mathis would not say that in court, because they know just as much as the prosecution. What they say could be plastered all over the media. So, but even though Eliza Mathis says something as important as that, you don't really hear it on the media, but still, she's not going to put something out there on the off chance that no one would say anything. Oh. Okay. So we went through a lot today, and we touched even a little on IgG. IgG heritage is interesting and what prosecutor fully used. Yep, but it also comes to sample of partial trace DNA. That is only they have, if they even have it. Right, I have the same exact thoughts. Like, yeah, we know it's partial trace, and it's kind of questionable whether they have it or not, especially the way that they've written things. Because that I keep mentioning the protective order, the protective motion for the IgG, and it's telling that when the prosecution talks about the STR, all they do is talk about the physical process of doing that. That's it. They don't connect it to Brian at all. So they're making these claims, but they're not even backing it up in their emotions. And then they have mainstream media to help gloss that over. Anyway, thank you all for visiting me today. It's been fun reading that. And Tara, thank you so much for that wonderful article. Wow, that one blew me away. That was great. Yes, so we need to start asking the question, what was it? How and when, not who. And that's going to change the landscape and hopefully reduce wrongful convictions. All right, everybody. If you have a DNA article you want me to read or go over, you can find me on Twitter or put it in the comments. I found some that way too. The more you know. Oh, thank you, Cassidy. That's so sweet. You all take care. Have a great weekend. Bye.